Nick, what is the 1980 Hague Convention and can you explain how it operates differently to other areas of law?
Yes, of course. The 1980 Hague Convention has been signed by over 100 countries, and it exists to provide a swift resolution to cases of international child abduction. The goal of the convention, the aim of the convention, is to bring about or to restore the status quo for a child. So that is the arrangements which existed before the child was wrongfully removed from one country to another or wrongfully retained in a second country. The underlying basis of the 1980 Hague Convention is to deter parents from moving a child from one country to another in circumstances where the parent might do so in order to gain a more favourable outcome or to prevent lengthy and costly court proceedings. The law which applies to the 1980 Hague Convention is the same in all of the countries which are signatories to the convention, and it's fairly self-contained. Because it's an international convention applying self-contained international law, some of the terms which are used in the convention and which are used in proceedings under the 1980 Hague Convention are unfamiliar to English lawyers. So, for example, the convention speaks of rights of custody and rights of access, which are the kind of phrases we just don't use anymore in domestic law in this country. But those terms are fairly self-explanatory and should be clear for most lawyers to understand. Proceedings under the convention seem dense and complicated. There can be lots of law in them, and it can look quite scary. The terminology is different. The proceedings can also be counterintuitive, simply because welfare isn't the court's paramount concern, as it is in most domestic issues relating to children. And indeed, a lack of sentimentality, a lack of focus on what's best for the child can often be part of the court's decision-making process. So a child may be returned from England and Wales to a country and to a situation which is less than ideal. But because the whole point of the convention is to return the child to the court of the child's habitual residence so that decisions can be made there, the lack of focus on welfare is perhaps understandable. The idea is that welfare decisions are made in the court of habitual residence rather than in England and Wales. Now, when lawyers are approached to act for a respondent, that is the person who has brought a child into this country or has retained a child here after an agreed holiday, that client is likely to be in a state of high stress and high anxiety. It may well be that they've just been served with documents that they weren't expecting. It may well be that the child's passport and maybe the parent's passport has been seized from them by the police. So they'll come to see the lawyer in a state of real worry and just not understanding what's going on. But it's important for lawyers to understand, and that's the focus of our book, that this isn't some alien jurisdiction. These are proceedings which are accessible and clear to most family lawyers. The cases proceed really quickly. In cases involving two EU countries, the expectation is that you will go from issue to enforcement within 6 weeks. And even in cases involving non-EU countries, the proceedings are supposed to be measured in weeks or a couple of months, rather than the best part of a year. For that reason, lawyers find it quite pressured, because you may be given a week or 2 weeks to prepare a statement, rather than in domestic proceedings where a statement may take months. And because these cases turn on submissions and on issues of law, the statements are really important. It isn't just a case of prepare a statement and then see how your client does in the witness box, because they're not likely to give evidence. These cases are often seen as the flip side to leave to remove or to relocation proceedings, partly because that's the way of doing it properly. If you want to move a child from one country to another, you seek the court's permission. The big difference between relocation proceedings and Hague Convention proceedings is that, of course, relocation proceedings are based on welfare, based on what's the best thing for the child, and Hague Convention proceedings are not. But these are proceedings which most family lawyers, given a little bit of understanding of the issues, will be able to grapple with, and hopefully, armed with this book, the issues become a lot clearer.